Bonani ninjani molweni afsheni tobelandra. Today we are back with a law of succession. And now, since I know that Friday is Yakala Ngempela, then I will have to go with MCQs, trying to answer some questions from the MCQs. So it's very much important for us to keep it going for 50 questions. Teddy died intestate and left behind the following relatives. His mother Mary, his Martha. His half-sister Candy. Candy and Ted had the same mother, but not the same father. His half-brother Ben. Ben and Ted had the same father, but not the same mother. His full-blood sister Sarah. So, rule number 1, when you read the question, you check whether the person has a descendant or has a surviving spouse. In this question, Ted has no children, Ted has no wife. Therefore, we check the next step, we check the people who are closer. People who are closer is the mother and father. We check the mother and father. Yes, Mary is still alive. What about the father? The father is not alive. However, the father has a descendant who is Ben and who is a full-blood sister Sarah. Remember, a full-blood sister is entitled to inherit from either mother or father. We have a half-sister Candy who's only related through the mother. But because Candy is not, does not share the father with Teddy, it means that Mary will inherit on behalf of Candy. Okay, so let's check what the rules says. Before we answer the question, it's very much important to understand the general principles of the person's blood relations. We have ascendants, descendants, and we have collaterals. Ascendants are those such as a mother, father, grandfather, those are ascendants. Descendants are those that from your child, your grandchild, those are your descendants. Section 1, subsection 4E, paragraph E made clear that a child who is adopted is deemed a descendant. So it means that that person it's part of the will. Is part of the will. Extramarital child does is eligible to inherit due to section 1O. We must know other stuff that a full-blood collateral, they relate from both parents. And then full half-blood, they relate through one common ancestors. We must also know, what is the other one that I want you to know? Before we go, step relations. Step relations cannot inherit intestate from deceased persons since they are not blood related. Step relations. Okay, let's start. Now we are going to the rules of the intestate succession. Because whenever we have an intestate question, we must check the rule of intestate succession. Number 1, we go to rule number 5. On that question, rule number 5 says, if the disease is not survived by a spouse or descendant, but by one of his parents and the descendants of his deceased parent, the surviving parent inherits half the intestate estate, and the other descendant of the deceased parent the other half. If there are no such descendants, the surviving parent takes the entire intestate. We go back to the question. Ted has a mother who has to inherit the half according to the rule 5. Then we have a Candy who has the same mother. Since Candy is no father relation, therefore mother will inherit on behalf of Candy. Mother, Sarah is from mother and is from father. We have already read that the full blood can share from either side. Because on the mother side, the mother will inherit the half. It means that Sarah will be able to inherit on the father side. Since the father is dead, Ben, because he relates to dead, based on the father's side will also inherit on the father's side. Therefore, the question of who will inherit the estate will based on the rule 5, which says that his mother will take the half of the estate since she's still surviving, and the other half will be shared equally between Ben and Sarah, since they will be benefiting from the father's side. Since father is dead, Ben and Sarah will be the likely to take the inheritance, share the inheritance. Let's go to question number 2. A child portion. This question is very easier. I won't even justify this question. Number 1, child, calculate by dividing the value of deceased estate by the number of steps plus the number of. This question was just easier. Let's go to another question. Shavi dies intestate and leaves the following relatives: his wife Wendy, to whom he was married in community of property; his adopted son Sam. We have already read about adopted, saying that adopted are eligible to inherit because they become the descendant. So Sam is a descendant of Shavi, his mother Mary, and his full brother Ben. The total value of a joint estate is 800,000. How will Shavi estate be divided? It is very much clear that we go to what the rule says. So it means that we are going to work out on the rule 3. Rule number 3 made it clear that when you are married in community of property, spouse is entitled to half of the before being divided between herself and the descendants. Therefore, in this question, who are descendants of Shavi? Shavi descendant is the adopted son Sam and her wife Wendy. Wendy will take 400,000 since they are married in community of property. Therefore, 400,000 will go straight to Wendy. Then after 400,000, you must also know the rules. The rules has made it clear that you must take a portion of a 250,000. If you have not read about that 250,000, then it's time for you to revisit it. I know that you understand about the 250,000. So Wendy will inherit 400,000 and then inherit 250,000 from Shavi estate, and then Sam will inherit 150, which is a residue based on the calculation of child portion, which you know. Therefore, number 3 will be correct answer. Wendy will get 650,000, 400 from the 400,000 which she shares, 250,000 from the child value, and then the adopted son Sam will inherit 150,000. Others, mother Mary and his full brother Ben, are not entitled in this estate. They do not inherit in this estate. Therefore, number 3 is the correct answer. Then we go to Tom. Tom died intestate and left behind the following relatives: his brother Saul. Saul and Tom had the same father but not the same mother. His stepsister Dala. We have already talked about this one and said his step does not inherit. Therefore, Dala does not inherit. His uncle John is the brother of his mother. His aunt Susan, the sister of his father. Therefore, in this question, it means that before Tom died, it means that the mother and father have already died. But the mother is survived by Saul on his side. The father is survived by Saul. And then the uncle and brothers exist. Therefore, according to this rule, it means that we go to rule number 6. If a disease is not survived by spouse, by children, or by either of his parents, his estate is cloven into 2 equal shares, each share going to the side of one of his parents. From there, that the half is divided between the descendant of the parents. If the disease therefore had a half brothers or sister, they will inherit through the common parent side. The disease full-blooded relation inherits through both parents. Then when we go to apply this rule number 6, it is very clear that a half-brother Saul, since he has the same father, will take the half of the estate, and then his uncle and brother and Susan, since they are surviving, they share the other half. So the question of who will inherit will be his half-brother will inherit. His half-brother will inherit half of the estate, and the other half will be shared equally by his uncle John and aunt. This is correct answer. So let's go to another question. Shanda died intestate and left the following relatives: his father Fred, his grandfather Gavin on his mother's side, his uncle Ben on his mother's brother. These are the ones that are surviving. His mother is died. His mother died, and then he left the descendant. Then remember, his father, his grandfather Gavin, his grandfather Gavin is the father of his mother. Therefore, is ascendant, not descendant. Is ascendant, not descendant. Therefore, we go and read the rules. The rules 5 made it clear. If the disease is not survived by a spouse or descendant, but by one of his parents and the descendant of his deceased parents, the surviving parent inherits half the intestate and the other descendant of the deceased parents the other half. If there are no such descendants, the surviving parent takes the entire intestate succession. Therefore, Fred is still alive. However, the mother has no descendant. Right? The mother has no descendant. Descendant meaning that he just have an uncle who is the mother's brother. They are not descendants. They are from other side. Therefore, the descendant is not available. Therefore, who will inherit Shanda's estate? His father, Fred, will inherit the whole estate because he's the one that is surviving and the other has no intestate. Let's go to number 6. The rule that provides that only male persons may inherit in terms of customary law is called polygyny, male primogeniture, monogamy, succession to status. Polygyny is when you married more than one wife. Male primogeniture is that only male person may inherit. This is a male primogeniture. And then we have a monogamy, which you only marry one wife. Polygyny, you marry more than one wife. And then succession status is the status for you to be eligible to inherit. Then we have a case of a Bear versus Magistrate of Kailicha. The Concord was asked to confirm a Western Cape High Court decision together with a North Gauteng High Court decision, both of which has declared the male primogeniture rule, which preferred senior males in the customary law of interstate succession, unconstitutional and set it aside. The ratio decidendi was like the Concord confirmed both judgments, declared the male primogeniture rule unconstitutional for violating the equality and the human dignity clauses of the Constitution, set aside Section 23 of the BAA and Section of the Interstate Succession. The interstate succession was imported to customary law to distribute equal child portions to all widows, descendants of the deceased, male and female, legitimate and illegitimate. This was also confirmed by the case of Shilubana versus Nwamitwa, where Nwamitwa was the first woman to be appointed as a traditional leader of Valoi tribe. So it's very much important to know about these cases, that transformation of a post-apartheid law of succession in the customary law. It's very, very much important. Then let's go to another question. Ted died intestate and left the following: his father Jim on his mother's side, his grandmother Ann on his mother's side, his grandfather Sam on his father's side, his great-grandfather Pete on his mother's side. Then we have a stepmother, which we have already dealt with this one. So because these all are surviving, they are all entitled to inherit. Therefore, it means that his grandmother, they are all going to inherit equally. Jim and Anna, they are all going to inherit equally. Alright? The person that will not be part of this inheritance is a Diana, because Diana is a stepmother. Teresa died intestate and left behind her husband Peter, to whom she was married in community of property. Teresa also left behind her children Mandy and Derek, as well as her adopted child Stewart. The joint estate amounted to 2 million. How will Teresa's estate be divided? Then I've already dealt with this question and I said, since they are married in community of property, it means that Peter and Teresa, Peter will have 1 million of his half, and then he will share 250 million, and the other will be shared with other. Therefore, number 4 will be correct answer. Peter will inherit 1.250 million, and then the rest will be shared with the children, who is the Mandy, Derek, and Stewart. We have already dealt with this question. Then let's go to question number 9. If a will is made in a country other than South Africa, which legal system formalities must be complied with in order for the will to be valid in terms of South African law? So it's very much important that we come and look at the private international law of succession. Then we know that the law of country where the will was executed, the law of the country where the testator was domiciled, the law of the country where the testator was citizen. Therefore, when we answer this question, we can say all are correct. All are correct. Let's go to another question. Testator Tom provided as follows in his will. I leave my house to my wife, Wendy. The residue of my estate I bequeath to my sister Mary and Nina. Tom and Wendy were killed in the same car accident. Tom's only surviving relatives were his sisters Mary and Nina and his brother Ben. Wendy was survived by her sister Susan, who inherited Tom's house. Firstly, in order to understand this question, you have to come and read the case of Gleylin versus Gleylin. In this question, you will learn about, this is the question, the Concord held that the words in Afrikaans to die simultaneously means that the death of the testator as a result of the single accident, irrespective of the fact that there was differences in exact time at which they died, it held according that the estate had to be administered in accordance with the will as if both parents had died simultaneously, resulting in the first respondent receiving the immovable property while the rest of the children received the residue of the estate in equal parts. In this question, since testator Tom has died and then Wendy were killed in the same accident, we do not know whether Wendy died first or Tom died first. Then as a result of that, because there's already been written that the residue of the estate should be bequeathed to the sisters Mary and Nina. Therefore, Mary and Nina will be the one who will inherit the house since they are still alive. And then Wendy will have inherited, but we do not know whether she's the one who firstly died or Tom firstly died. If he was firstly died, maybe we'll be saying that Susan will be the one who inherited from Wendy. However, it is not sure whether Wendy has actually inherited. Therefore, Mary and Nina will be the one who is suitable. I hope you understand this question. The capacity given to an existing trustee to appoint an additional trustee is called. So it's very much important to read about the appointment of a trustee. A trustee may be appointed by the founder when nominated by a trustee by name of appoint, stipulate another trustee when such power has been conferred upon him in the trust instrument, power of assumption. Therefore, we know now that the answer is a power of assumption. The capacity that is given to existing trustee to appoint additional is called the power of assumption. Testator Xolisa provided as follows in his will. I leave my yacht to my two sons, Wongani and Andile. After his death, Xolisa's only surviving relatives were his son, Andile, his daughter, Denise, and his grandson, Gavin. Gavin was the son of Wongani, who died before the testator, who inherited Xolisa's yacht. Remember, the Xolisa's yacht in the will have made it clear that I leave my yacht to my two sons, Wongani and Andile. And after his death, Xolisa only surviving relatives were his son, Andile, his daughter Denise, and his grandson Gavin. Gavin was the son of Wongani. who died before the testator. So the testator said Bongani, and Bongani dies, then Gavin is the son of Bongani. Then the question is asking who will inherit. It is very much important for you to know about the direct substitution which came with subsection 2C. Section 2C, there's a so-called statutory representation. Provide that if a descendant, whether as a member of the class or otherwise, would have been entitled to a benefit if she had not predeceased the testator, or had not been disqualified from inheriting, or had not after the testator's death renounced his or her right to receive such benefit, the descendants of the decedent shall, subject to the provision of section 2C1, prescribe, be entitled to the benefit. Therefore, if we go back to our question, it's very clear that Andile and Gavin, since Gavin substituted Bongani ex lege in terms of section 2C2 of the Will Act. Therefore, this will be the correct answer. Now, let's go to another question. Sorry, I was reading there. Let's go to question number 13. The master may dispense with the appointment of an executor if the deceased died intestate. The value of the estate is less than 250,000. The value of the estate is less than 125,000. The beneficiary is applied to the master not to appoint an executor. When we deal with the interpretation of increased jurisdiction by the master office, the chief master issued a directive 3 of 2015, which effectively from 17 August, with regard to the interpretation of increased jurisdiction amounts by various master office to ensure a uniform approach to section 18, subsection and 13 of the Administration Act. It will dispense with appointment of executor if value of estate does not exceed 250,000. Therefore, we'll be saying that the value is less than 250,000. Therefore, number 3 was correct answer. Let's go to number 14. Question number 14. Ben and Charmaine were married in community of property. Ben murdered Carmaine. In light of recent case law, which of the following benefits will Ben be permitted to receive after Carmaine's death? The person who murdered the testator. A person who intentionally caused the death of the deceased is incapable of inheriting any benefit in the estate of the deceased. And then the right in Afrikaans. A person who has murdered the deceased parent, child, or spouse may not inherit from the deceased. The relevant case here is ex parta Steenkamp and Steenkamp. Ex parta Steenkamp and Steenkamp. Then it is very clear that if we go and read Steenkamp, we'll find that none of the answers are correct. Therefore, number 4 is the correct answer. Now, when we go to question number 15, it reads as follows. A testator Thabo provided as follows in his will. I bequeath my farm to my son Sipho, provided that he obtains an LLB degree within 6 years of the time of my death. If he does not, my sister Anele will inherit the farm. These bequests provide an example of. So it's very much important that you know that in a law we have something we call a direct substitution. Right? It takes place when the testator appoints a beneficiary to inherit a benefit, and at the same time appoints another beneficiary to take the place of the first mentioned heir. Substitution may take place either in the alternative direct substitution or one benefiting the fiduciary substitution. So whenever there's an issue of substitution, there is. Effect of this section is that if a testator appoints the descendants of his beneficiary and that descendant renounces his benefit or predecessors the testator or is disqualified from inheriting. Now when we go back to the question said, I bequeath my farm to my son Sipho, right? SIPO must get LLB degree, which can be a time clause, which can be part of the time clause, right? However, if it does not, there is a substitution here, which is the sister Anele who will have to take over. So this guy has some fulfillment, and if he failed to fulfill, there is a substitution which will take place. So this is a direct substitution saying that if he fails, then Anele must take over. So this question is part of a direct substitution. However, some people can say it's a substantive, suspensive time clause. Substantive time clause is when things are happening in the future. So here it will be say, I bequeath my farm to son Sipo, provided that he reach the certain age. So when he reached the certain age, he became. So here he has to reach the LLB degree. If he doesn't, then there is a substitution which will take over, which is Anele. Which one of the following persons will not be able to claim maintenance from the deceased in terms of the Maintenance of Surviving Spouses Act 27 of 1990. So maintenance of surviving spouse, of the maintenance of the surviving spouse. Who will not claim maintenance? We all know about the effect of a Volk case versus Robinson. Is that a heterosexual life partner is not automatically regarded as a spouse or surviving in terms of the Maintenance of Surviving Spouses Act, and cannot claim maintenance from the deceased life partner estate. Go and read this case of a Fox versus Robson in order to understand. Therefore, we'll come here and say that the deceased of a heterosexual life partners. Let's go forward. If a charitable trust becomes impossible to carry out to the letter, the court will allow to be carried out for the purpose of near as possible to the original purpose. This is called a power of appointment is permissible in the case of charitable trust, where it is impossible to carry out the will of the testator to the letter. The court will allow the trust to be carried out cypress as near as possible. Therefore, we know the correct answer. The correct answer is number 3, right? What is the process called where a court adds or deletes or changes something in a will because the testator had made a mistake when making the will and their will does not reflect its intention correctly? So we cannot be a deletion, alteration, or rectification. It's a rectification takes place when a court adds, deletes, or corrects something in a will because the testator made a mistake and it does not reflect his or her intention correctly. Therefore, the answer is rectification. There must be a rectification. That was a clear answer. What is the provision called that is attached to a bequest and that is the result that the bequest terminated the happening of an event that will certainly take place in the future? We have a suspensive time clause, a resolutive time clause, we have a resolutive condition, a suspensive condition. In order to understand to answer the question, it's very much to understand the unconditional bequest and the condition. When there's a condition, it is uncertain future event. Therefore, it means that the resolutive condition and suspensive condition are likely to take in uncertain future events, right? Why? Because they are part of the condition, right? And then we have unconditioned. Then we have absolute bequest may, however, be made subject to time clauses. If a bequest subject to a time clause is subject to an event where that will certainly happen in future, so it's unconditional. Though it may be certain, uncertain when it will arrive. A time clause may be suspensive or terminative. A bequest subject to a suspensive term clause is bequest where the beneficiary will enjoy the benefit only at a certain future time. A bequest subject to a terminative time clause is one of which the beneficiary's rights are terminated when a certain time arrives. Then we have a condition bequest. Conditional bequest, one which depends on the future event, which is an uncertain in this sense that it may or may not occur. Okay, that's one. We have a resolutive and we have another one which is suspensive. Then resolutive, a bequest subject to a terminative condition is one which the bequest is made to terminate if a particular uncertain future event takes place. All right? Okay. Then we have a suspensive conditions. If a bequest is made a subject to a suspensive condition, the beneficiary does not get a vested right to the benefit bequest unless and until a particular uncertain future event takes place comes. Right? So now we know that uncertain are based on the suspensive condition and then the resolutive conditions. Then these two term clauses are made for when they say unconditional, which means that there's a certain that it may happen. Therefore, the correct answer we can therefore say that is a resolutive time clause, because the question is asking attached bequest that is the result that the bequest terminated the happening of an event that will certainly take place in the future. And then those two say that they are uncertainly take place in the future. Then we go to the testator Tom provided as follows in his will. I leave my house to my daughter Danielle, provided that she never leaves South Africa permanently. The bequest is part of what? In a law we have something called nandam praeceptum, which you have to come and read for you here on the 9.5. Then you will understand about the nandam one. Then the correct answer here is a nandam praeceptum. Right? Then let's go to another question, 21. Testator Tyson made a valid will in 2018. In 2019, he decided that he wanted to change the name of one of the beneficiaries. He used a T-Pex to erase the name and then wrote in the name of the new beneficiaries. Will this amendment be valid? Yes, provided he signed next to the amendment. Yes, provided a two-witness sign. Will the commission of oath and attach the certificate? No, because it is not allowed to use T-Pex in his will. It's very much important to go and read the interpretation of the rule in terms of the grammar, the punctuation, and everything about the will. As a general rule, clauses it will that the testator erased or cancelled and therefore revoked may not be considered when interpreting a will. Furthermore, words and phrases must be given the meaning they had at the time that the will was made. However, since a will applies from the moment of testator dies, the death of may not be considered determining the certain words. Then you go and read about the ordinary and plain meaning, how they must be drafted, the will must be drafted. It's very much important for you to read. Then you will understand that no, because one is not allowed to use a T-Pex in a will, they should be retyped or re-executed in order for that will to be valid, so that there will be no sorry, I have a flu, guys, so that there will be. For more information, guys, I've already given you that you must, for more information, you must call me on 061 984 2135. 061 9384 2135. I can teach you the law of succession, then you will pass. What is the principle called according to which the executor of an estate must, under certain circumstances, take benefits given to certain heirs by the deceased during his or her lifetime into account when distributing the estate among certain beneficiaries. It made it clear that collection is a process where, under certain circumstances, a descendant will receive certain benefits from a testator during the testator lifetime as to collate in such benefit. Blah, 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 blah. Therefore, the correct answer is collection. Which court may interpret a will? Where courts interpret the will? The will, we have already told about the master court. Did we talk about magistrate court? Did we talk about the master court? Master court is in high court. Therefore, the court that can interpret the will would be a high court. This was a straightforward question. I don't want to waste our time with this question. A testator drafts and executes a will to regulate how his or her estate and other affairs should be dealt with after his or her death. As soon as a person dies, his or her will is submitted to the master of a high court and is scrutinized for validity. Right? So this question is different from asking which court or courts may interpret a will, where it can be interpreted. Meaning, if we have a dispute in will, where we must go? Should we go to the magistrate court or should we go to the high court? However, we have the one that says that they submit the master of the high court and to be scrutinized for validity. For validity, you must go to high court, which is the master, to check whether the will is valid or not. So what about magistrate? It's very clear that the master of high court does not have an adjudicative function. In other words, the master does not have a judicial power to settle a dispute. The reason for this is that master has neither the facilities nor the power to hear evidence. He or she has an administrative functions only. This, when it comes to the interpretation of wills, the master interprets a will literal, even regard to the actual words used by the testator. If one wishes to deviate from ordinary and literal meaning of a will, proceedings must be instituted in the high court to interpret the will. The lower courts do not have a jurisdiction to hear matters involving the validity of an interpretation of wills. Then we know that the high court, right? Okay, let's go to another question. Which of the following person cannot inherit from a deceased person in terms of intestate succession act? We know without even reading that the juristic person cannot inherit. Unborn child can inherit through nasaturious fiction. Validity marriage we talk about. Prodigal person can also inherit. Therefore, juristic. Let's skip this one talking about the cases, because the case is something that you do. I think that I've answered more than how many? 24 questions. I think tomorrow I'll answer another questions. Let me just say tomorrow I'll start from 25 until we finish this paper. Thanks guys for watching, and let me say again that if you want more information, you just WhatsApp me on WhatsApp 061, or you want me to teach you about the will, you WhatsApp me on 061-984-2135. Thanks for watching. Let's meet next time.